speak up, please?
Yes.
Okay, we will try to do that. Our environmental analyst at the board, and I guess I'll start by taking notices of appearance.
Jeffrey Commons and Aaron Kasicki for the Public Service Department.
Leslie Cadwell, legal counselors and advocates for David Blittersdorf.
No.
Robin Kay, Chairman of the Select Board of Irasburg.
I'm sorry, what's
Brian
your last name?
Sandville.
K-A-Y.
Brian Sandville, Irasburg Select Board.
And can you spell that, please?
Last name?
Yes, please.
Sandville, S-A-N-V-I-L-L-E.
This is for parties entering notices of appearance, or people who are thinking of being parties. It's not an attendance list for other purposes. So if you're not considering seeking party status in some way, feel free to speak up, but the purpose of this is who's appearing to as a legal representative of the pre-hearing conference.
I'm just a resident of Irasburg.
I'm Senator Robert Starr. I represent Orleans and Essex County and parts of Franklin County.
Anyone else? Okay. The purpose of today's pre-hearing conference is, among other things, to set a schedule for this proceeding. And I don't know if any of the parties have had a chance to talk about a possible schedule. I think the pre-hearing conference memorandum pretty much outlines the scope of the proceeding, which is I'm supposed to look at the facts concerning the construction of the tower, whether it was lawfully constructed, and whether it complied with the appropriate requirements of Section 246, which is the net metering statute, and also to make recommendations to the board of further action. I will note that the department had asked that we conduct a show cause proceeding. This is not explicitly labeled as such, but the board's order makes clear that this is open under Section 30, which is the penalty statute, Section 209, 246, 247, and 248. Ms. Cadwell.
Just a couple things. I'll turn to the department for scheduling. I just want to correct, you misstated this is not net metering, it's Met Tower.
Thank you for that.
You're welcome. Just so the folks in the room know, you do know the difference. And the other question in terms of scoping that I had is the order cites 248 and 247. And I don't understand why 247 and 248 are at issue here. This is about whether there was a certificate of public good under Section 246. And so I'm just asking, at least insofar as notice to my client goes on what the issues are, why the order opening investigation cited two statutes that I don't think are at issue.
Well, that's certainly something that can be argued in the case. I will note that Section 246B states that the board shall set rules for issuing CPGs for temporary installation of one or more Met towers, meteorological stations, under the provisions of Section 248. It doesn't say pursuant to the criteria of 248. It says under the provisions of 248. So one can argue about whether that is intended to be a 246 certificate, a 248 certificate, or some hybrid thereof. That has not been formally interpreted by the board in one way, shape, or form. That's why 248 is mentioned, because it doesn't say that you get a 246 CPG, it says you get a CPG under 248.
Well, one of the reasons I asked the question is because I am representing another client in a similar proceeding, and the board's order opening an investigation did not mention those statutes, so it surprised me to see them. I think perhaps, and I'll defer to the department on scheduling, that maybe we use some time to brief whether 247 and whether the penalties available in 247 should apply to a proceeding that's actually coming under 246.
If we need to If you think that there's need to do that, we can certainly build that into the schedule.
Great, thank you.
I was not aware of the other order. I was aware when writing this order of what the statute says,
Thank you.
which is why it reads the way it does. Yes.
Can we also build into the schedule a motion to intervene?
Any schedule will have a motion, the opportunity to intervene for interested persons. I do want to make clear, this is about the construction of the meteorological tower. We are not getting into issues related to what may be proposed in the future. This is solely about the construction of that tower is the charge right now. Mr. Thomas?
If I may, I'd like to actually follow up on Ms. Kay's comment and make a comment that relates to schedule. One of the things that I've observed happening sometimes in board proceedings is that we start down the road of testimony and discovery and filings without knowing who the parties are, because motions to intervene, the date is set after dates for other events to occur. And I'd be open to discussion. I just wondered if it would simply make more sense to know who's on the train before we send it out of the station, and have that process earlier rather than later. I don't know if there is a desire for especially speedy action in this docket. We're flexible and, as I say, open to discussion, but I wanted to just raise that as a suggestion.
I'm certainly happy to adopt a schedule that does that and has intervention at an earlier time. I assume that nobody's had a chance to sit down and talk together about that.
We really have not. That's correct.
My next question is, does it make sense to go off the record and allow a time to do that, or is it better to, we can still go off the record and I can either hang around and help form the schedule, or I can walk away and let you guys talk.
I'd be fine with going off the record to discuss schedule. Other parties are
Rather than meandering on the record
Yes.
While we come up with dates.
You're talking schedule, you're talking who is interested in intervention.
But what we're talking about is going off the record to just talk about schedule, simply the schedule, dates and events and so forth, and not who's a party. That's a little further down the road.
May I make a suggestion? This is sort of following up on what Mr. Common suggested, and I think, because I understand the concern, it really is to make sure that if there is an intervention and additional interested parties are allowed to intervene, that the schedule really take into account their needs as well. And so it may be appropriate, throw this out there, maybe this is what we take offline, to have a deadline for motions to intervene, and a reasonable time for the hearing officer to rule on those motions, and then within a certain amount of time, once the parties know who's there, we work together on a schedule and then present that, rather than try to fix dates. I don't know if there's someone other than the folks from the Irasburg Select Board that are going to want to intervene. But I do, I am interested in an efficient process, rather than have the hearing officer get scheduling requests. It may be, as Mr. Common suggests, better to, have the train, know who's on it, and then we can proceed together.
To the best of my knowledge, there's no one besides the select board that are representing the town of Irasburg that want to intervene.
The one thing, we end up setting up an opportunity to intervene. We understand that you're likely to be the only ones as select board members, but we need to set it up. We don't know whether there's an adjoiner who has information or has an interest in the outcome of the proceeding. So we need to. I'm open to setting a schedule that just has a motion to intervene and the parties propose something, but it's just in terms of, for those who don't typically participate, a typical schedule has things like motions to intervene, periods for discovery, periods for submission of pre-file testimony, and then discovery on the pre-file testimony, and then going to hearing, and the end of the brief, and that's the sort of the scope of it. They're not separate meetings, most of them are done on paper, and typically, unless we schedule a status conference, there's an initial site visit. You may not see me until hearing date.
How do you go about accepting a site visit?
In general, to make any particular request, a motion of some sort, or if you make, right now, if you think a site visit is appropriate, I would try to encourage working with, assuming you're planning to intervene and assuming it's granted, neither of which, I can presume at the moment, I would suggest working with Mr. Commons and Ms. Cadwell, and if you think that would be appropriate.
I do.
Yeah, so, well, I inferred as much, but I'm not going to presume any particular outcome at the present time.
Would like to request a site visit.
So, I don't know how you feel about a intervention only, order right now. It's certainly easier for me to write.
Yeah.
A couple lines.
I'm okay with it. Why don't we go off the record for a few minutes and let people talk and see what the will of people are.
So if we should just set an intervention deadline. Today is the 6th of October, is I recall.
Excuse me? My name's Leslie Cadwell. Are we on the record?
We're off the record.
Okay.
Feel free to have, I'm sorry, I probably didn't say the manager for
You
it.
did.
Okay, we're off the record.
Okay.
Joanne was waiting for me because if nothing happens until I authorize it.
Right.
You
So-
guys, go
Yeah.
ahead.
I mean, are any potential interveners, how do you feel about doing it, just proceeding, having the motion intervene? Other parties, Ms. Cadwell and I would file responses, and then International would make a ruling, and then we set a schedule for what's going to happen, and we can put in dates and things. As I say, I'm open. I wanted to toss that suggestion out there. See what works for people.
Does that make sense?
Yeah, okay, so when would be a reasonable time to prepare a motion to intervene? How long would you like?
I need a moment to think.
Sure, absolutely.
The last 2 weeks of the month are really tight.
Yeah, we can do it by the 16th. October.
He's getting old, Leslie, that you have to stand up and stretch.
What's that?
He's getting old, that you have to stand up and stretch.
Making sure she can get a good shot of me.
And it's there's no requirement.
Indeed it is. Longer from Irasburg. So what's your role here? And
I'm a
are
consultant.
you advising them?
I work as a consultant to people, advising them on the process, because most people don't understand the process.
Can we get that on the record?
We're off the record right now.
We can have on the record?
We can get that on the record.
Awesome.
Why don't we hash out this?
Perfect.
But I'm not sure if it's,
I've been here many times, my role is well known by the board, and I never talk to the board. So if you want me to talk to the board, I'll be happy to talk to the board.
I wasn't looking for it, but
No.
if Leslie seems to.
No, I just like to have the, I think it's helpful for folks to have, have it clear on the record that you're helping them, that's all.
Oh, we're pretty clear.
Yeah, we'll have the record show that.
So you're saying October 20th?
Mike,
That works fine.
Yeah, so it's 2 weeks from today.
Then a week?
Responses a
2
week.
weeks.
Can we,
Well,
I was
go ahead.
going to say the end of the next week, the 30th, but we don't have to go that far out, probably.
They can do for their responses now.
Actually,
For the
let's,
responses.
I would like till the 30th if we could.
Okay.
If we can do it sooner, we will. I have one attorney that only works part-time, so.
So reply to response back to 10:31. That's the last day of the.
No, 10:30, unless you work Saturdays now.
I spent the weekend working.
Can I make another request? Can I request that the filings are done electronically?
That's, well, you know, that's, let me say. number
Well,
one, the
that's a
board- the
unanimous
board will
vote on
not-
that one.
The board will not recognize electronic filings unless you specifically ask the board and not me.
Right.
I will say that,
And not me.
and not Mr. Young. I find that everybody finds electronic filings really helpful, to get an electronic copy of stuff. But the board functions on paper. So, you know, that's what you need. You need to send paper to them. If parties agree to accept service electronically, you can do that. Under the rules, technically, you have to send everybody the piece of paper.
In addition to electronic?
Yeah, and I will say that the department would like to get paper and electronic. But
So-
it's very helpful. And, you know, again, one of the things about having intervention late was that the department was getting requests for, can you send me copies of all the filings in the case? Because I just was allowed it to be a party. That's that's problematic for us, frankly. So I think there's gotta be easier ways to skin that cat.
Well, one of the, I think that's a great idea. You still have to, unless the board allows us all to avoid having the hard copy on the day that it's filed. I think it's a great idea to exchange stuff electronically, and one of the things I thought, because I understand the department has a lot of requests for stuff that's filed in these cases, and I know the clerk of the board is overwhelmed with paper and all that. I'm gonna make available a link that will have everything that's filed here, the official filings, that can be made available to everybody. And whether you guys link that to your website or whatever, or VCE, you know, links it to their website or whatever, at least everything that's filed with the board, all of the discovery, all of the motions, all the letters, all of that, I will make a box folder available. If you give me your email address afterwards, you know, I'll give it to you, and that link you can send around, so that it's publicly available to everybody.
My intention wasn't to avoid paper.
No, I got that. No, I totally got that. It's convenience.
Yeah, no, it's convenience, yeah.
We really do understand that.
And I will point out that if you want to submit electronically to us, we have a lot of times electronic filing with paper to follow, you know, for electronic counting for time purposes, but you need to talk to the clerk. I have a lot of authority in that case, but paper shuffling, I don't.
So I actually think that this is a great suggestion, in part because I live a distance from Montpelier, but I don't live the distance that the folks from Irasburg live. To actually get paper here, I actually know how hard it is to get overnight mail from just Castleton. In board proceedings where the board itself sits, my experience has been that the board has allowed us to do electronic filings the day they're due, followed up by paper. And I think I would suggest to the parties that we jointly ask for that relief from the board, so that you won't have to have the paper sent except by regular mail, which is cheaper than doing express or FedEx. And that we do the electronic file. So I just want you to know, Mr. Hearing Officer, I'm gonna make that motion, and hope the folks will join and see if we can get the board to allow us to do it in this case.
I may just say that's fine, you know, and I'll just see.
Okay.
Department has no objection to that, that's a great idea.
I mean, I'm fine with that. The only negative is, it's just a straight logistical, which is, I don't always know when, you know, I don't always find out when the electronic can move very quickly. And
I don't know how to solve that problem.
yeah, I know there are ways to solve that problem. That's number one, and number two, I really hope we don't get into an argument if we go this route about, oh my God, it was filed a day late. I may not be the most responsive to such requests.
So, since I assist a number of people with this process, my understanding, and I want to get clarity on this, is,
Can I just hang on a second? There are like a number of cameras going on in here. This is really distracting to me. I got some guy taking pictures over here. She's filming. I have these folks setting up. I don't think the rules allow this many. This is very distracting and confusing. Can we have a decision on who's going to be filming this?
Doesn't bother us. Doesn't bother me.
I'm actually fine with it. On the other hand, I'm receptive to the idea, if you guys are doing this, please try to stay out of, jumping in the middle here is a little distracting. But if they're set up now.
so I just wanted to get clarity on the board's rules in general and specific to this case too. My understanding is that the hard copies must be at the board on the day of the deadline.
That is the way the rules are.
Right. And then-
Leslie's request is that I order that instead, that if you file electronically, the paper can come in afterwards.
For the board.
For purposes, well, if you file electronically with everybody, you're okay.
Right, no, I'm just talking about the paper copy. So
The paper
I'm trying to
copy.
understand your rules. So the paper copy for the board comes to you on the day it's due. That's never been a problem for the citizens that I felt. Then the other parties receive it with the postmark date on the date that it's due. Is that correct?
No.
Or
No.
the parties are also supposed, because nobody has ever come back and said, you're late by doing that as a postmark date.
No, you, in your sentence, you use the word received as opposed to, if you drop it in the mail,
Mhm.
that counts as service.
That's what I thought. So that it can be mailed on the same day and hand-delivered here, and the electronic filings all go out. And
Right.
so there's never been any problem with that with the citizens that I've been assisting.
Can I just say, part of the reason why, if the department only got paper and got it 4 days after the deadline, it could be problematic in a document with a tight schedule. The reason I think that that's not problematic is that electronic service has become so common. We commonly get copies of filings electronically, and so then, if I've got the electronic, the paper can come in when it comes in.
And we've been doing that in
Yeah,
every case
that's
that
all.
I've been assisting. People are getting the electronic copies on the day it's due, the board is getting the hard copies on the day it's due, and it's being mailed the day it's due. As long, I want to make sure those are the correct rules, and then we will.
Those are the correct rules. The variation we're putting in here is for purposes of delivering it to the clerk's office. You don't, if you file it electronically on the day it is due, the paper, you can drop the
Come to the
paper in
board
the mail
later.
and the paper can come in a day or two.
And that's specifically the board we're talking about.
That's for the board. For the other parties, it's the same,
The
you
postmark
drop
date.
it in the postmark but everybody's agreed to electronic filing of the group here anyway. So if you send Leslie and Jeff an email, I'm looking at you, even though it's technically it's the town of Irasburg, and I apologize for that. The select board members of Irasburg who are more likely to be intervening. That's, the electronic will serve for purposes of getting them to it, and.
But they're still
they've
gonna do
agreed
the
to
hard copy.
They've asked for a hard copy as well, so that's how we're gonna work.
Thank you for the opportunity to make sure that we're understanding the rules.
And I'll clarify that piece on the record, thank you. So I'm okay with the 20th and the 30th for intervention deadlines and replies. And then we'll set a schedule for setting a schedule thereafter, because I'll need to pull on the motions to just, Leslie. Yeah, I see your hand. I see your hand even when I'm not looking at you.
So how about a telephone status conference to talk about schedule after you rule on the motions to intervention?
I would like to do that. Let me see how many parties there are.
Okay.
Because.
Well, here's why, because if it's just the department and Mr. Blittersdorf, I would be really happy to not drive my car here to talk about schedule. If it's more, I suspect that folks from Irasburg, maybe not, maybe you want to come to Montpelier to talk about schedule again, but we could do it by I'm just trying to make this convenient for everybody. Including you.
You actually don't need to sell me on this one because back when, because I like telephone status conferences. My point is, if we get 5 people intervening, I've been on conferences conference calls, whether you get too many people, and when you lose the visual cues and you have a bunch of people, it is a pain on the file.
Fair enough.
Therefore, my decision on whether it's a telephone status conference, which is what I would prefer, will depend upon how many people are allowed on the bench.
Thank you, sir.
I'm going to ask you a question that you're not going to answer, if I don't give you the chance to answer.
Do you want to put it on the record?
No.
Okay.
I can put it on the record anyway.
Okay.
But just to make things easier. Is it likely that if Irasburg intervenes, your client or you as a client would not object to it, so that we could simply deal with that now and avoid the whole intervention stuff?
I don't know the answer to that question. Had I known you were going to ask it, I would have had an answer for you today.
I just thought if there wasn't an objection, we might be able to make things a lot easier. And I'm not putting you on the spot. So
No, you are, but that's okay. That's you know, I can take it. What I can do is commit to find out and get back to both the chair and the department, and then communicate to the board.
If you
It's a great question. Thank you.
If you think that you may not, and I haven't asked Jeff the same question, because maybe the department would have an objection even if Mr. Blittersdorf would not. But if there is no objection, I'm happy to just. We still need to set an intervention deadline because of potential parties who aren't here today. But if everybody knows that the select board of Irasburg is likely to be admitted as a party, it might be easier for people. And so I would encourage you, both of you, to at least check with your clients and see whether you might just be agreeable to admitting by through stipulation. That's not in order to do one thing or another.
Well, thank you. That was a great question. I appreciate it.
I've been around for a couple of years. I have a few ideas. Anything else before we go back on the record?
No, but I will say you still have about the same amount of hair you did 20 years ago.
That's not true. And it's also a different color than 20 years ago.
Fair enough. Nothing more.
Leslie was hired to start at the department right after I left, so we didn't overlap. She's had to consult me from a distance for 20 years.
Can I ask you a question? So assuming that there is an issue with respect to prevention, we don't stipulate to it, do we want to build in a tentative sort of timeframe for this potential telephonic status conference right now?
It's going to be early November, and if I get the stuff on the 30th, I'm just trying to think when I'm having, I like the idea. What are people's availability later that week? Not Friday, because I go off to Texas on Friday, the 6th.
Which week?
Well, the 30th is the end of
Right.
October, so presumably it would be the week of November 2nd, right?
The week.
So, which means I had to turn the order around immediately.
I guess my question is, do you want to turn around and order that?
An intervention in order just isn't that hard to write. The bigger question is what else. I'm just, so if that week doesn't work for people, then it's going to have to be after the 11th, because that's when I come back from Texas.
That makes more
So
sense.
either the week of the 2nd or after the 11th.
Yeah. The neighborhood meetings.
Or after
Right.
the 11th. Or after the 11th.
Okay. So tentatively, let's say, is the 12th work?
What time of day?
Afternoon only works for me on the 12th.
Afternoon? So tentatively 2 o'clock? And this is tentative because I don't want to guarantee a telephonic conference call until I know who's in. it's useful to stipulate the facts, but I think we'll save that to the telephone status conference. But based upon Ms. Cadwell's, your letter, Leslie, it seemed like it might be possible to reach a stipulation as to most of the facts, the implications thereof, and what that does for other things. And I wanted to explore that, but we can, so be thinking of that for scheduling purposes.
I would, and I'd invite, my experience, and I was, for the sake of folks here who may not have experience as much before the board, my experience is the board asks really good questions when it wants information. So I would welcome that earlier in the process than later. If you have stuff that's on your mind, that you'd like the respondent or the department or the interveners or something to address, I think that would be very helpful. You don't need to respond, I just want to welcome that earlier in the process rather than later.
I appreciate that, and I will say I might have questions that would help to guide things, but I want to hear your story first as to what happened. And that won't come until after I get pre-file testimony or a stipulated set of facts, because I want to know what you think happened before I start asking those questions.
Fair enough. That's very helpful in and of itself.
Because I don't want to. Yeah, I want to hear the I was going to say the petitioners. I want to hear Mr. Blittersdorf what happened before we get anything. And I suspect others around here. A lot of it's in the letter, but there, obviously the letter was a page and a half long. Maybe a few other facts.
Fair enough.
Anything else before we get on? Okay, now we're ready to go back to the. Oh. Okay. Cool. That's absolutely fine, because I don't think we said anything other than it was probably informal in my conversation. That's cool. We had an off-the-record discussion in the schedule. Parties agreed to an intervention deadline of October 20th. Replies on the intervention. Any intervention requests, October 30th. There's a tentatively scheduled telephone conference call on November 12th to discuss schedule. That will be at 2 o'clock in the afternoon. And as I said, that's tentative. We'll have to wait and see who intervenes, how many parties, as to whether I conclude that makes sense. I think that summarizes what was off the record. Ms. Cadwell, you had a request.
I did, and I just want the record to reflect that Annette Smith from Vermonters for Clean Environment is here, and I had asked Ms. Smith what her role is, and I would like to get that on the record.
If there's no objection to it.
My name is Annette Smith. I'm Executive Director of Vermonters for a Clean Environment, and I serve as a consultant to citizens and towns who need help understanding the public service board process.
And your role here is as an advisor to the select board
I'm a consultant to the select board.
on the public service board process in this particular case?
Yes.
Okay, thank you.
So is there anything else we need to do this morning? Hearing nothing. Thank you all for your time. And we're adjourned.
Thank you.
Enjoy.